So it is now 7:32 p.m. on July 15th, 2025, and I am officially opening the meeting of the Zoning Appeals Board of the Town of Boxborough. And I'm going to do a roll call vote. Please acknowledge your presence when I call your name. Sean McCormick.
McCormick, present.
Van Stunts.
Stunts, present.
Mark White. And I saw him acknowledge, but his mic's off or something.
Oh, no audio?
I got you now. So Mark White's present. Michael Toops informed me by email that he is a direct abutter of one of the cases, and he's decided not to attend this meeting at all. So anyways, he's acknowledged that he can't be heard on the particular case, and we'll talk about it when that case comes up, which would be momentarily. So let's see here. Alec, do we have any correspondence?
Nothing at this time, Mr. Chairperson.
Okay. Also present at the meeting is our head planner and our associate planner, Alec Wade and Ian Gilson. And let's see what we've got. Alec, I don't see on the agenda a time for the public hearing in 975. Do you know what the specific time was? Was it the opening of the meeting?
Yes, we had scheduled this one for 7:35.
Okay. So since Michael's not going to be here, we'll just open that up. Hopefully the applicant's around. In accordance with Massachusetts General Law, Chapter 40A, Boxborough Zoning Bylaw 4.1.3D, Business Industrial Uses, 2.2 Board of Appeals, and 2.3 Special Permits, the Boxborough Zoning Board of Appeals will conduct a public hearing continuation to review the application for a special permit submitted by Goldsmith Preston Ringwald on behalf of the applicant, BHG 109 LLC. The property located in the business district is owned by Brett Gutheel. The applicant seeks to construct an 8-unit contractor storage building and associated site improvements. Is the applicant here?
No, Mr. Chairperson. The applicant is not here, and they have sent advance request for a continuation of the public hearing.
Okay, and I think that's because he's working his way through various boards in town, like the CONSCOM and the Planning Board.
That is correct. He is scheduled to return to the Planning Board on Monday evening.
Sounds like good cause to continue the hearing. So would you have a date in mind and a time?
Yep. So looking ahead, this is a 5-Tuesday month. So if the board would like, they could target Tuesday, July 29th, or if you'd like to get back on your regular schedule or stay on your regular schedule, the next regularly scheduled meeting would be August 5th, depending on summer availability.
So board members, is there anyone who, Mark, go ahead.
I can't be there on the 5th. Oh, but actually I can't act on this one anyway, so it doesn't make any difference.
Oh, you would recuse yourself from this one otherwise. Okay, yeah. Gotcha. Okay, so with that in mind, does anyone else have a scheduling conflict with the dates Alec mentioned? Than?
I'm on vacation both of those days. For that.
Both those days.
Yeah, for that 2-week period. So I mean, I could join if need be. If there's a I can bring my computer and jump on if need be. If we can't extend it for some reason longer than that, but I'm planning on being away those 2 weeks.
Okay, so now we're in trouble because we took our associate member and we have bumped him up to a regular member. So first of all, congratulations, Dan, for the upgrade. It was well earned, and we now are short an associate member. So I would propose, Alec, can we bump it further so we don't conflict with Dan's schedule, because we are down 2 members.
Yeah, I believe that's practical. Given the planning board schedule, there's a real possibility that if another continuation is needed, they won't be heard again until August 18th. So August 19th would be your second in the regular schedule of meetings. Do people have availability on the 19th?
Sean, how are you doing? Stan's good?
You guys should be good.
Okay, I'm good as well. So we can open the meeting, and we'll just have to pray that Toops is going to be on with it. So I think that's what we're going to do. Would someone like to make a motion to continue this hearing to that date? And what time would you suggest? 7:35?
Yes.
Okay.
So moved.
Second.
Okay. Moved by Than, seconded by Sean. Any discussion? Hearing none. Than?
Aye. Stuns aye.
Sean?
Cormac, aye.
And Mark Barbadoro, aye. Okay. So that one's taken care of. That's good. I like these meetings moving fast. One moment. Okay, am I too early for Kendall Road, or should
No, you are good to go. We double booked the hearings for 7:35 p.m.
Fabulous. Okay, in accordance with Massachusetts General Law, Chapter 48, Sections 2.2, 2.3, and 4.3 of the Boxborough Zoning Bylaw, a public hearing will be held on Tuesday, July 15th, 2025 at 7:35 p.m. to consider a special permit application received from M&M Home Services to alter a lawfully non-conforming structure. The property located in the agricultural residential district is owned by Robert and Jessica Levesque. The applicants seek to convert an existing porch into living space. Is the applicant present?
I do not see them present, and I don't have any correspondence indicating for an extension or that they would not be present.
Okay. Well, let's see what we can do while we're here. And we may put them, if we can't resolve this tonight, we can continue them. We'll have Mark as a member and hopefully Toops as a member on another day that's closer to our regular meetings. But Mark asked for some information. Did we get all the information that Mark was asking for? Mark, did you get a chance to look at the packet?
I'm still unclear if I look at the property card, I think the current floor plan would be the 936 was the original. I'm trying to determine what the original structure was at the time of the bylaw being passed.
So I'm going to tell you what I think, but I'm going to let the professionals guide us. But my understanding was, looking at the record, is that there was a small cape, okay, with a deck. That was the original structure. Then there was 2 permits that came after the fact. And the small cape and the deck predated the bylaw in accordance with a letter from Inspector Morse at the time that Alec put in the packet. So that house in general was pre-existing non-conforming. Then there was 2 permits later that one permit was for the screen porch, and then there was another permit for a much larger addition. And we have a plot plan that indicates the larger addition as well. And with that in mind, I will let Alec answer, and Dean, who did a lot of the homework here, answer the questions.
Yeah, if I could, Mr. Chairperson, I think this would be a good opportunity. I think Ian understands this application fairly well. He prepared your planner's report and did the additional research. So if it's okay with you, I'd like to turn this one over to Ian to present the application on behalf of the applicant in their absence.
Great. Thanks, Ian. Take over from here.
Yeah, no problem. Let me pull up the planner's report real quick. Got it right here. But yeah, so I guess the question, if I'm not mistaken, Mark White, is, where does this stand if it's potentially near or already over this 100% additional or extension of gross floor area? And from what we've seen, they were both permitted properly with the building inspector and building department at each time that both the porch was made in 95, the screened-in porch was made in 95, and then the addition was made in 2001/2002. I stipulated in my email, I'm not sure if we have special permits on file, as our files are away getting digitized. And yeah, essentially what this comes down to is creating this screened porch, putting up windows so that it will be a livable area. These people cite seasonal allergies as a deterrent to enjoy their screened-in porch living space. As this doesn't change the gross floor area at all, I'm not sure that there's a big issue in giving this special permit. But I do think you raise a good question as, what did the permits look like before? Were they was this bylaw of extension up to 100% of the gross floor space being considered? And, does this 100% reset each time the building is permitted? And when 10 years pass, does it once again reset and it's lawfully non-conforming? So I think we kind of have this question, and then this application might seem a bit different from it. Yeah, Than.
So
I see two board members' hands up, but I'm just going to check with Mark. Mark, do you want to ask a question before we go to Than?
Well, I guess I'm still unclear. So what was the square footage of the building at the time of the initiation of the zoning bylaw in the gross floor area? And
it looks like, I'll share my screen real quick of the floor plan.
So that would be the 936 square feet.
936, yes, because this wood deck would not be counted as it was not roofed.
Okay, so then my other question would be then, is this proposed, and I'm trying to find exactly the word to describe it, it's going to remain a porch, but it's just going to replace the existing screens with windows. So does that make it part of gross floor area or not? That's my question. Because if it is, then clearly it would push them beyond the 936 square feet initially permitted.
So I'll say the screened-in porch, since it has a roof over it, decks, porches, if it has a roof over it, then it is technically counting toward the gross square or the gross floor area. So it was already counting as this, and it will not be adding to gross floor area if they put up the windows.
But when was it permitted? Now let's go back to when it was permitted.
The porch was permitted in 95.
And that was that predates the bylaw or not?
It does not predate the bylaw. The bylaw regarding extensions up to 100%, extensions or additions up to 100% is from 1965, 4 years after the original Cape was built.
Okay, so then it would be, we would then, because you can't find the records of any special permit being issued, you'd have to assume that it had to be done by special permit because it was increasing the nonconformity of the building. So if you add the 936 to you can't add the 252, it's already in there. So the 868 would be added to the 252, which occurred later, and I'd have to assume there was, that up front, what is the up front anyway, that up front blue?
That is it's a porch with an overhang above it, and I believe that should also count to gross floor area.
So I got to say, I think then this thing is over limit. I don't like to say it, but I mean, it looks pretty obvious that that's what it is.
So I tend to agree with you, Mark, on the fact that it probably shouldn't have been allowed to be built. But I think where you and I might differ is that because it was permitted, both additions were permitted. There's an actual, I mean, there was a so-called plan of the screen porch, and the other one, there is a site plan that was provided, and I don't think Ian found the building plans of the addition to the right, but both were permitted. So they came, they asked for permits, they received permits, and both, and I think Sean's going to say this when I give him the floor, but there's a section 48, section 7 situation where when things are existing over 10 years, they're considered lawfully pre-existing non-conforming. So the question is, since a porch is counted in gross square footage and so is an enclosed porch or porch converted to living space, would this be automatically disallowed? And I'm not saying that we shouldn't necessarily disallow it, but I am saying that it is not necessarily, quote, automatically disallowed because they are not increasing the floor area, I think is the argument that I was going to make. But before we unpack it, I think Than and Sean have had their hands up for a while. So Than, go ahead.
I was just going to ask if we know if they are going to heat that space or insulate underneath it. Are they really changing it from a porch to a a permanent living space, four season living space? Are they just putting windows up so that they can keep the pollen out? So that was my question.
Do we have an answer on that?
It doesn't stipulate in this entire application whether or not they're going to do that. They do only say our intention is to replace the existing screens with windows. So
4 season though.
Yeah.
Yes, into a 4-season room.
Okay, so that means insulated and heated.
Okay. Right. That was my question, is whether they mean insulated and heated or they're just saying 4 seasons because it has windows on it.
Would it make a difference?
It just makes any non-conformingness less. It's still a porch then. It's still a 3-season porch and things like that. So it may make that was my only point, is if there is more like that gross the usage of that gross floor area doesn't change.
So the only increase in nonconformity would be the addition of windows as opposed to screens.
Right.
Sean.
Yeah.
Thanks for waiting.
What is non-conforming about this house?
There's lots of things. It's front setback, one side setback, and the lot area.
The lot area is too small.
Yeah.
Yeah, so I can.
It's 55 rather than 60,000. Gotcha.
Front setback is under 40, side setback is under 30. Like I said, those bylaws were adopted in 65.
So it's increasing the nonconformity in the sense that only in square footage, not in setbacks. And in the 55,000 square foot is a limiter. So that's really 2 nonconformities.
Well, there's a question on that. Alec, go ahead.
But,
Yeah, so
but there's not. But if the covered screened porch is counting towards their GFA right now, then they're not increasing the non-conforming nature at all. And I don't know why they need a special permit from us. Period.
Well, I'm looking at the building permit from 1995. The remarks in the building permit are, must conform to Boxborough zoning bylaw, Mass State Building Code. I mean, if they didn't pull a special permit for that, I guess lacking any special permits that were given in either of these additions, we're a little bit of a impasse because those may have conditions saying no further increase. I mean, who knows what they say? We put conditions on special permits all the time. But, I mean, I'm as I want to give this to them. I don't think it's bad. I just reading what the bylaw says, and it's kind of like, I mean, sure, if you say that they did it and it's been 10 years, then I'd say, okay, well, we missed it then, but are we going to miss it now?
So, I think I agree with, first of all, Mark, your point about if there was a special permit and we don't have it in front of us, and that special permit had conditions, then those conditions would need to be followed. But I agree with Sean on the idea that these things, regardless, have been permitted for over 10 years, so the entirety of the building is lawfully pre-existing non-conforming, and the gross square footage is not increasing because the old square footage included the screen porch that they're enclosing. So there's no change. I also agree with Sean that he's questioning whether the non-conforming nature is increasing, and Sean can probably think of there's two very famous there was an appeals court and there was an SJC decision that actually outlined what would be considered an increase in the non-conforming nature of a 1 or 2 family dwelling, and it even cited enclosing open porches as not increasing the non-conforming nature. So I don't know if that we should make a decision tonight on this. I think we have unanswered questions about the potential for a special permit. I might ask Ian to go for a deeper dive if he can through the records and maybe look for some special permits on that. I don't know how the board feels about that. What do you guys think about that? I hear Mark's concerns, and I think maybe we need more record.
Mark, could I actually speak to this real quick?
I forgot to call on you. Sorry. Go ahead.
That's okay. That's okay. I wanted to make sure the board had the opportunity to talk through it as much as possible. So in this case, not only do we not have any special permits immediately available to us, though, but on a dive of Mass Land Records, no special permit has been recorded against the property. And ultimately, the special permit does not take effect until it's been recorded. That's an important element to any special permit we issue and has been for many decades. And so even if a special permit was issued in these cases, it was not recorded and therefore not acted upon to its fullest extent. I also would go so far as to say that I agree with a lot of the statements that have been made here. Most notably, my opinion is that this porch and the changing from a screen porch to a window facade does not increase the nonconformity. And where both building permits, the 1995 and the 2001 permit, were issued more than 10 years ago and were permitted by building permit, it really takes out a lot of after the fact enforceability. If these structures were put up without a building permit, then they could be ordered down at any time. That's just the fact of it. However, where a building permit was issued, the only outstanding matter is the zoning compliance of these. And where we have no special permit to back them up, but it's greater than 10 years, it's now frozen in this state. I would further contend that we're probably up against the 100% limit, but where this is not adding to the gross square footage, there's nothing to increase the nonconformity here. I would even typically encouraged Ed, this is probably a permit you can issue just by simple building permit, but where we don't have a special permit on file for either of the previous editions, I do think a special permit is pertinent in this case, and I think we then have to encourage and strongly push to make sure the property owner gets that on file so that we have a document codifying the existing state, the existing conditions, and then you can apply any reasonable conditions you think are necessary so we can make sure that future additions, future changes, they're defined whether they do or do not need to come back before this board.
I appreciate that, Alec. Board, what are your thoughts here? Mark, go ahead.
Wait, I mean, I don't see anything on the later permit for the addition. Is there anything in there for anything for that addition?
For 2001?
Yeah, I don't see,
So the
oh, one
document,
permit, that's all I see is the permit. I don't see any plans, anything else.
yeah, O1 completion edition and O1 permit
And that was
edition.
Giampietro. Go figure. So I think it would be fair to say that this building has experienced two additions that should have been subject to special permit process. The first one in 95 and the later one in 2001. And so now, because nobody did their job back then properly, then now they've gotten the bonus of having two additions put on their house, the second one of which probably wouldn't have made it. The first one probably would have been no problem. And I don't know. I mean, what's the intent of the bylaw? I'm struggling with that because I mean, again, I believe people should be able to do with their house whatever the heck they want as long as the neighbors aren't, up in arms. And so part of me says, fine, just give it to them. But I really think that this is not what was intended by the bylaw in any form or manner. And this is not just one miss, but it's two. So somehow, I mean, they can make a case and they could probably take it to court and win it. And in that case, I might just vote for it anyway. But I think this is clearly an instance where it's been missed not once but twice. So I don't know how to handle that.
Would it benefit the board if we continued and we had Ian pull the plans for the large addition?
I mean, for me, no, because clearly it was permitted. Clearly it didn't have a special permit, if Alec's correct, which is that is nothing in the registry of deeds. There's no proof of it. I think that's a good catch, Alec, because rather than go dig it all out, I wouldn't have minded to see the paperwork to understand how that slipped through the cracks. But I don't think it's going to change anything.
I will note sorry, I can't find where to raise my hand. They submitted the site plan for the O1 edition as their site plan for this. As you can see, they only highlighted the porch, the extent of work. So that is why I didn't include it in the history folder, and I regrettably should have. But we do have the site plan for the addition, the O1 edition, in the application itself. I should have clarified that in my emails.
John.
Yeah, just remind me when. So the 30-foot and the 40-foot setbacks were in the 1960s.
Yes.
And when did we go to 60,000 square feet?
That would have been in the same bylaw, if I'm not mistaken. So 1965. Whereas this was built, the original Cape was built in 1961.
Real quick, Ian, do you have attachment A? Can you sign into our servers real quick and just pull up attachment A, the various lists of changes to the bylaw? Because I will note, my recollection is that over time the town has modified the minimum lot area requirements for various districts. So I would just caution we want to double check that one.
Yeah, give me 1 second.
Thank you.
I'd also like clarity, if possible. It may not be able to be done at this meeting, but the 100% rule, that probably was not original to the bylaw, and it could be that one or more of these additions were added before the 100% rule. So I don't know if you guys, go ahead, Ian.
Yeah, so the 100% rule is what I was originally looking for, and I pretty much went back through decades of bylaws, because as you'll see in our bylaw, Mark pointed out, it is its own subsection 433. In about sometime in the 80s, it was looped in with the original clause that gets into non-conforming uses. It was just in a big paragraph before we broke it into a smaller subsection.
Minimum lot size bylaw was 4/17/64, approved 7/21/65.
Thank you. Yeah. And but they were one and the same. Both the setback requirements and the 100% extension or addition were both from 1965. Let me pull that up. Let me try to find.
I'm looking at it right here on the zoning bylaw and zoning map amendments, 6/14/65.
Would you be able to share that?
Sure. Okay, hold on. Try it again. There's my share button. Oop. And where is it? Right there. Guys, see that?
Still loading on my end.
Oh.
Seen it yet.
No, me neither. It's weird. Let's try it again.
Here you go.
Didn't see it?
Yep.
Okay. So it was right here.
Yeah, but that doesn't tell you that it's at 60. In 1956, we were at 40.
40. Yeah.
And then it says amends minimum lot size bylaw, but it doesn't say how. And then in 1968, it goes to 80, but that's not town-wide.
Hold on.
Look, the answer might be that they got those building permits because they were the lot wasn't undersized. It was just they had a non-conforming setback. They were building in the other direction, and they were like, no problem. You're not increasing any non-conformity.
That's possible. You'd have to find the zoning bylaw at the time of the application.
Yes.
But does it
I thought they had
change
all the old
anything?
ones.
Does it change our discussion?
No, this is entirely academic, Dan.
Okay.
I mean, I think after 10 years with a duly issued building permit, you're
Yeah.
legally non-conforming.
Yeah.
Yeah, I get that part too. I mean, I'm just thinking, how far can you stretch this? That's all. Because,
So
I mean,
if-
ultimately, it may come back to us again in a different form. And
If there is no, like they're asking us for a special permit, could we grant them a special permit to do this with conditions of there is no further extension, et cetera, et cetera?
Yep.
Yeah.
So then we can clean up the fact that there is no special permit in essentially saying, hey, we're allowing you to do this thing because it's really no change as long as you had the existing special permits from history, but we don't find them. Therefore, here's what we think they should have been. Bam, you now have a special permit to do it. Go ahead and do it. And moving forward, we're now cleaned up on your lot.
Yeah. I think that's the only answer that I would be happy with, but we are not a full board and one board member can kill it. So we got to make sure that we all agree or it will not pass. So is that good with everybody if we do that?
I mean, I'm good with it. I think it clean. I think without knowing what the special permits are, it's a pre-existing non-conforming based on the 10 years in existence. So, and there isn't much change to it, but they're asking us for a special permit. So we can clean up the history and it makes things cleaner for the town going forward that way. So I think it, because if we just said, well, you don't need a special permit, then something else happens to this lot and they're like, well, here you go. This should be fine. I can now add another 1,000 square feet in the back right corner because all the other things are existing non-conforming. But if we put some recommendations or some stipulations on this special permit, then there's one in existence, and we've cleaned up from the historical lack of special permit that we think should have been there.
I'm comfortable with that. Frankly, I was trying to think of the court case. I think it might be Bjorkland, but there is a case where the Supreme Court of Massachusetts literally says enclosing porches is not an increase in the non-conforming nature. And to Sean's point, there is a possibility that they did not even need to come before us. So we've got them. They've asked for the permit. Building inspector says he won't issue the permit without a special permit. So let's issue conditions so that this building does not expand anymore in the future because we have reasonably determined that they are already at or exceeding their 100% rule. Does that sound reasonable to everybody?
I can buy that.
Okay. Sean, can you buy that too?
Yeah, that's fine.
Okay. So we're kind of in agreement that they should get it. So the question is what should the language sound? Does anybody have some good language that they'd like to put in to that effect?
John?
Poor Sean has to do all the heavy lifting around here.
Yeah. He is an attorney. I mean, no better person to draft it than the attorney.
Yep.
Yeah, I mean, I would probably do this. I would probably do this decision where we say, look, that we have this bylaw. Well, I don't know. Look, I don't want to overcomplicate this, but the more I'm staring at section 4.3.3, it's problematic. It really is.
Go see 4.3.3.
Mark, Mr. Chairperson, I will note for you, it appears the applicant has entered the meeting as well.
Oh, well, that's good. We should get them into the conversation. So is that Jessica?
Yes, I believe so. Jessica, can you hear us?
Yes, I think I'm unmuted.
Yep, we can hear you.
We can hear you.
Okay.
Hi, Jessica.
I apologize. We've been standing outside the FinCom meeting because everyone told us we had to come in person.
Oh, sorry.
No. It said everywhere, join the Zoom, but, whatever. Different people here at the town hall said you had to come, so we did. Anyway, I'm here with Ben Lawson.
Yeah.
Who is representing the contractor, and I'm the homeowner.
Great. So we were talking about your property, so I'm just going to bring you up to speed briefly. We have a bylaw, and it's been in place a very long time. And it says if you have a non-conforming structure, that structure can't increase more than 100% of its gross floor area.
Yep.
And we were looking at your, we don't have all the gross floor areas we are assuming, but it looks like you're at the end of you're at the limit of that. You've already exceeded it. Okay. So we also noted that your property, before you owned it, received 2 building permits, and the board is reasonably confident that you should have received a special permit for each one, and none were granted. That's through no fault of the previous property owners. It was just maybe a clerical error on the part of the building department that allowed these permits to be issued without special permits. So now we are you're basically kind of in agreement with the fact that you can enclose this porch because you're not technically increasing the gross square footage, but we are going to put language in the decision that says no further increase in the gross square footage of the property will be allowed. So do you understand what we're driving at here? This is the limit of your building is going to be the size of the building that it is today. Once you put your windows in and make a 4-season room out of it, whatever the building inspector needs for, materials and methods and insulation and windows and heat and all that for that porch, that's the end of it.
I understand.
Okay.
Yep.
All right. Just wanted to be clear on that. And it also reminds me, we should probably, before we close the hearing, we should see if there's anybody else. Is there anybody else on the line, Alec? Okay. All right, that's good. Then we don't have to hear from public comments. That must mean your neighbors are okay with this enclosure.
They are. I asked all of them who can see any piece of my property basically before we started, because obviously I don't want to waste anyone's time. So I got thumbs up from my neighbors for what it's worth.
Okay, terrific. So Sean, have you been mulling that over in your mind, what you think it should say?
Yeah, I mean, I think the answer is that it's got to be something like in light of section 4.3, which provides that no change of a non-conforming structure shall result in an extension of the structure to more than 100% in excess of the gross floor area of the structure. It says existing or begun when this bylaw was adopted. And I think that's the language that we've been struggling with, because that doesn't limit it to the current application. It looks back to the beginning of the bylaw. So I think we can say that we are making I guess we're saying we're making a finding that this application doesn't exceed 100%. I think we need to make that finding, or else we can't grant it at all. And then then the condition is just no further increase in gross floor area. Absent, I don't know, absent a variance, I guess.
Well, sure. So I'm reading it now to 4.3.3. No change, alteration, or extension of any non-conforming use or structure, in this case we're speaking to the structure, shall result in an extension. Well, it's not an extension, or an increase in the use to more than 100% in excess of the gross floor area. So a finding in this case is enclosing the porch will not increase the structure to more than 100%, even if it's already beyond 100%. Does that sound true?
Yeah, I think that's right, Mark. We're making a finding that the relief we're granting is basically not in violation of the bylaw.
Okay. Mark.
I've been scrolling the zoning bylaw and zoning map amendments. I got down to, I don't know, page 6. In 1988 was the increase. So Sean, you were right. So in 1988, the increase went from 40,000 to 80,000. 823.88. So the first edition
after that
was okay. No special permit required, but the second edition would have required a special permit.
Oh, interesting.
Yeah. So I don't know. I don't know what to do with this. I mean, in excess of the gross floor area of the structure or of the total area of the use existing or begun when this bylaw was adopted. I mean, it's kind of pretty. I mean, if this was Harry Hilberg sitting here, I know what he'd say. But I'm not Harry Hilberg. So I think I'm okay with it. I think that the best way to go at it is the way Sean just said. I mean, the key you said just now, Sean, is we have to find that it's not in 100% in excess, but
no, we have to find that this alteration will not increase it beyond 100%, which is a difference.
In excess of the growth when the bylaw was adopted.
Right, but this will not
because
increase.
It's already existing.
Right.
But allowing it. Okay, I mean, again, whatever words. Again, Sean's the attorney, so I trust him to get it in words that make it immutable.
Alec.
I think I have captured it in the form of findings, and then I have also written down the conditions that Ian had previously put forward so the board can mull those over if they'd like. I'm just going to bring up my share screen, and I can live edit the findings and any conditions you think are reasonable. So you'll note under the findings, I think I took some liberties and simplified it down. The proposed alteration does not increase the non-conforming nature of the structure beyond 100% of the gross floor area, where the existing porch is already covered and was built under a building permit more than 10 years prior. You want to take some of that out?
Yeah, Alec, how about the proposed alteration does not result in an increase of more than 100% of the gross floor area? And then I would do as separate findings, I would say a separate finding is that the porch is already covered and was built under a building permit more than 10 years ago. Bulletproof.
I like your confidence. Would the board like to proceed on to conditions? Ian had originally stipulated 4 of them, and then I'll note, Mr. Chairperson, I think you had also noted a potential cap on further alteration of gross square footage, which I've highlighted in bold here.
So I'm fine with that.
Do we
Board
need
members?
to close the hearing?
We're still working through. No, we have to hold a vote, so we can still talk about this.
All right. Sorry.
Any thoughts? Mark or Sean or Than?
I'm still reading it. Hold on.
In your 1A, overlaid or overlayered? Or overlaid the right way with an AI.
Does the is it square footage alone or any other? I mean, because what if they reduce square footage in one place and then still do a permit for non-conforming setback in some other place? Say, for example, you remove the deck and then you add it on to the. So I'd include
So
not only gross square footage or setback.
contend that condition 3 here gives some flexibility. So if the property owners, current or future, wanted to modify the layout of structures on site, they would have the right to come back in and ask you for approval. However, we further stipulate that the gross square footage cap has effectively been met and cannot be approved. So it would give them flexibility to maybe play around with that number, take a little away from maybe the porch in the future, and then do a shed elsewhere. But it stipulates they'd have to come before you and they can't exceed the gross square footage as it is today, the date of this decision.
How about adding something like or reduction of any setbacks?
That's not what 4.3.3 doesn't talk about setbacks. It's only gross floor area.
Yeah. Okay.
And reducing setbacks while being in conformance, they still have two sides that they could decrease the setbacks without increasing the non-conforming nature. So I think we probably couldn't put that in without deciding tonight that they can't expand in any direction. And I don't think that's necessarily the right decision.
Okay.
So then, Mr. Chairperson, if I could, it almost sounds as if would you think that this may be considered an overreach, this first half of the condition, but the second half is pertinent to the decision?
No, I like it. I like the first.
No, that stays.
Yeah, I like the item 3 in its entirety. I'm happy with it.
Yeah, because the bylaw 431, the last sentence says, does not increase the non-conforming nature of said structure. So they're going to come, if they're going to increase the non-conformity, then they have to come back.
I will note that this is a 3-condition decision as written. This violation section is our standard language just included on the back end of all of our decisions.
Mm-hmm. I'd love to see the permitting paperwork on this thing from the when the addition was done. I want to know how that happened.
And to that I say, I look forward to our Laserfish system up and running so we can easily pull those things up.
That was a great idea. Whose idea was that?
It wasn't any one person's idea, Mark.
No, it wasn't. It wasn't at all, Mark. But somebody did initiate it. Anyway.
Mike Giampietro. Okay.
Mr. Chairperson, if the board is satisfied with these conditions, you could first vote in the set of conditions. You could then vote the decision based on these findings and conditions.
We need to close the public hearing first.
Yep.
Sean, did you say we should close the hearing? I'm sorry. Okay, gotcha. That's what I was thinking too. So, property owner,
Yeah.
Are you okay with what you're seeing here?
I'm not seeing anything, to be honest with you, because I'm on a phone in a room in the town hall because we're in the wrong place. Closely. What I understand is you don't have paperwork from before I bought my house, so that's an interesting little thing someone's going to find on microfiche, so that's exciting. What I'm hearing is you're going to probably conditionally approve with the understanding of the sort of a one and done. You know, we can't get any bigger. So this is it. So unless we're playing with weird setback numbers and making porches smaller and other things bigger, we're done.
That sounds about right.
Okay, perfect.
Awesome.
Thank
All right.
you.
Do we want to close a public hearing? Does anyone want to make a motion?
So moved.
Okay. Second?
Second.
Moved by Sean, seconded by Mark White. Any discussion? Hearing none. Mark White.
Thank you very much. Bye-bye.
Bye. Sean
Bye.
McCormick.
McCormick, aye.
Dan Stunts.
Stuns eye.
Mark Barbadoro, aye. Okay. So Alec, you were suggesting that we vote the decision as written if we decide to vote to approve.
Yes, Mr. Chairperson. As is typical, I'd also recommend that the decision be, or the chair be authorized to sign the decision on behalf of the board. We'll of course fill in the complete details, but the findings and conditions are the pertinent information for tonight.
So moved.
Second.
Okay, moved by Mark, seconded by Sean. Any discussion? Hearing none. Mark White,
White eye.
Sean McCormick,
Cormac, aye.
Dan Stunts,
Dunce eye.
Mark Barbadoro, aye. Okay, does anyone want to make a motion to approve, or did we just do that?
We just did that.
So we're good? We're done? Okay then. Fabulous. Okay.
Mark, did you enlarge your basement?
Say what?
Did you enlarge your basement? Looks really big now.
Your background.
Well, I didn't increase the floor area ratio or whatever.
I was going to say, we got to check on that.
Okay. So that was the second one. So update on Board of Appeals rules and regs. All we have left. So I went through. I aligned all of the references in various sections to one another. So they are, as far as I can tell, in alignment. The only things I think we still have are a run through of Ian and Alec, and also we never firmly decided on numbers and quantities of paper copies and what is needed. Alec.
I do have a recommendation for numbers and quantities. The applicant should be required to provide one digital copy, as well as 3 paper copies in all formats, 11 by 17, full scale, as well as any narrative documents, with further stipulation that additional copies may be required at request of the department.
Okay. Does anyone have any thoughts on that suggestion from Alec?
Why do we need paper copies?
So we are required by law to keep one record copy. That's our filed copy. Additionally, between myself, Ian, maybe the chairperson, or if we have Sue Carter or a consultant, we like to have one departmental copy that we can mark up. We can kind of share around as needed. And then finally, we have one fresh copy, untouched, available for the public to come and review at any time. If board members were to request their own copies, then we would further request copies from the applicant, but 3 in most cases is sufficient.
Okay, so we're expecting them to supply the copies rather than us just printing out our own.
That's correct.
From the digital one.
Yes.
Just Than, sometimes these things are 2 feet by 3 feet by 25, 30 pages.
Oh, yeah, no, it's one of those. It's sort of how modern are we, and how modern do we have to be versus not, kind of thing. Blueprints are huge. And if we're getting those, then it's, I wouldn't want to print them out either. I don't own a plotter. But okay. As long as there's a reason and we've got a rationale for those numbers, then I'm cool with that. So
okay. Anybody else? And I think we lost Mark. We might wait till he gets reconnected. But any thoughts, Sean, on copies? Definitely need a couple paper copies anyway.
Yeah, I mean, look, that makes sense to me. 3 copies makes sense.
How is the board feeling about just moving this ahead and having Alec and Ian vet the, go through it and do make sure that I did actually get all of the numbers aligning with all the references and everything else? Or is there something, do we want to go through it at another time at a public meeting?
Can you spell out those options again? If we kick it back to staff, we're not voting to approve it yet, right?
Right. We're going to see it again.
Yeah. Okay. Because there are a few typos um, yeah, all right, we'll catch them.
So I guess what we'll do is, then it sounds like, Alec, is you and or Ian will do a complete vetting of it, and then we will distribute the clean copy to the board and give the board a couple of weeks to look at it. We don't have to. There's no great rush, and let everybody have a chance to go through it line by line and come back with any final revisions, and then we'll add the revisions or deduct what we need to, and then vote on it at a later date.
Okay.
Does that sound like we can do that? Alec, can you guys have the time to go through it?
Yeah, absolutely. We have over a month between now and your next meeting. In fact, the question I have lingering is, would the board like us to post the required public hearing for your August meeting so that at the time of that meeting we can make final revisions and you can approve that night, or would you like to make those revisions and then schedule the public hearing for a subsequent meeting?
I'd like to do that. Does that sound okay to the board?
Option A or option B? I'm fine with either. I just didn't know.
Well,
That was a two-option question.
yeah, I mean, I guess it depends, Alec. What do you think your turnaround is? If you're going to take the month, which is totally fine, then I don't necessarily think we're going to be voting on it in August.
Yeah. Let's cautiously, I'm going to say we can absolutely review this and get it to you by August 5th. That would give you 2 weeks to review it before the 19th. If the board would want additional time, then we should not schedule the public hearing.
But if we schedule the public hearing, we can continue it just like any other public hearing. So it's not.
Yes.
Even if it isn't ready, we could continue it.
That's correct. Yes.
I'm anxious to just get this thing done. And like, to me, to check that box off would be, huge, because I'm tired of looking at the frickin' thing. I'm sick of it.
Let's do it that way then. We'll try to get it done August 19th.
Awesome. Is that okay with everyone else? Okay.
Yep.
All right. Awesome. And the final item on our agenda is reorganization of the board. So again, Michael is not here, but I did talk to Michael and I told him that he didn't want to be here because he had to recuse himself anyway. So I think he had other plans, but I did tell him that it was on the schedule to reorganize. And Michael's comments to me was, I'm okay not being involved in the reorganization. So it's up to the board if they want to. We can nominate Michael as chair, or we could nominate him as clerk, whatever we want to do to him for putting us in this position. But either way, Sean had expressed an interest last time, and I kind of grabbed the chair from him, out of his hands. So I'm, Sean, if you want to be the chair this go around,
I was actually going to suggest, Mark, that maybe you take another year.
Well, it's up to you, because I will vote for you for chair for sure. So,
well, I appreciate that. I think it makes sense to stick with you as chair. That's where my vote would be at.
Okay. Does anyone else want to be chair? And seeing shaking of heads. Okay. So I would accept if you nominated me, but I would ask. Do you want to be clerk and be chair next year, maybe? Or
I'm happy to be re-voted in as clerk. Let's take the
1 year at a
I don't
time.
make plans a year in advance.
all right, fair enough. Does anybody else want to be appointed as clerk? Okay. All right. Well, I don't want to make motions while I'm the chair, so.
Right.
If someone else wants to make them.
So I move to re-elect Mark as chair.
Second.
Okay. Made by Sean, seconded by Mark. Any discussion? Hearing none. Sean McCormick.
McCormick, aye.
Mark White.
White eye.
Dan Stuntz.
Dunn's aye.
And Mark Barbadoro, aye. And would someone entertain a motion to nominate Sean for the clerk?
Nominate Sean for clerk.
Second.
Seconded by Than. Any discussion? Hearing none. Mark White,
White eye.
Than Stunts,
Stunts aye.
Sean McCormick,
Cormac, aye.
and Mark Barbadoro, aye. Our next meeting, when's our next meeting, Alec? Hope you're muted.
19th. August 19th.
Okay, awesome. Is there any other business that we want to discuss? I'm hearing none. Maybe we should get out of here.
Motion to adjourn.
Second.
Motion
Third.
by Sean, seconded by Mark. Any discussion? Hearing none. Sean McCormick,
McCormick, aye.
Mark White,
White eye.
and Than Stunts.
Stunts aye.
And Mark Barbadoro, aye. And congratulations, Than. You earned it. Thanks for joining the board. Whether you like it or not, you're here. Awesome.
Thanks.
All right, guys. Have a great night.
Talk to you